Our last speaker for the morning will be Professor Dorian Warren. Good morning.
Morning. Chairman Liebman, members of the board, thank you for allowing me the opportunity to present my research findings to you this morning. My name is Dorian Warren, and I'm an assistant professor of political science and public affairs at Columbia University, where for 5 years my research and teaching is focused on labor politics, labor policy, and social science methodology. Before my present employment, I taught for 2 years at the University of Chicago, and I completed my doctoral work in political science at Yale University. Now, several weeks ago, Columbia University released a study I co-authored with Professor Kate Bronfenbrenner of Cornell University entitled "The Empirical Case for Streamlining the NLRB Certification Process, the Role of Date of Unfair Labor Practice Occurrence." Our research is directly relevant to the proposed rule changes to streamlining representation election procedures. Simply put, our findings, using a unique data set of unfair labor practices in representation elections, indicate the need for streamlining and modernizing the NLRB certification process. Our data shows that employer opposition, or what's been called communication in these hearings, begins much earlier than expected and continues every day all the way through to the election. Let me first briefly explain our research methodology because I think it's important in interpreting our findings. And then second, I want to share just some of the most significant findings from our research. And again, these findings have direct relevance to the proposed rule changes, and they also refute many of the arguments presented yesterday and this morning. So first on methodology, the data for our analysis originate from a thorough review of primary NLRB documents starting from a random sample of 1,000 NLRB elections that took place between 1999 and 2003. Using the Freedom of Information Act process, we requested all unfair labor practice documents for every case in our sample from the board with a response rate of 99%. Our method of measurement for this study is the time between the date of occurrence of serious unfair labor practice allegations, the date of the petition filed, as well as the date the election was actually held. We read through the entire ULP document files, including employer responses, settlement agreements, complaints, dismissals, withdrawals, testimony, affidavits, and board and court decisions until we located the specific date for each serious violation in the charge that was found. Now, this was time-consuming data to collect, and for this reason, the data I'm presenting today is only for the last year of our sample of 2003. Now, by the standards of rigorous social science research, not simply a few select unrepresentative cases, we have systematic and not anecdotal evidence about when the employer campaign begins, and from this evidence we can make valid and generalizable claims about the NLRB election process. So to the findings. We have heard hyperbolic claims from those opposing the proposed rule changes that employers do not have the opportunity to express their views to workers, that they are ambushed suddenly when workers file a petition for an election, and that the proposed rule changes would eviscerate workers' ability to make an informed choice. And in fact, one witness even claimed yesterday that employers do not know about a union campaign until petitioners present their cards. All of these claims are empirically false. Our ULP documents show that some of the most egregious employer opposition starts long before employees have even filed a petition. So some numbers. 47% of serious allegations are filed before the petition, and 86% are filed before the election. 67% of all serious allegations are filed within 2 weeks after the petition is filed. 47% of all serious allegations won by employees through board or court decisions or settlements occurred before the petition was filed, and 89% are won before the election. 60% of allegations of interrogation and harassment are filed before the petition. 54% of allegations of coercive statements and threats are filed before the petition. And finally, 39% of allegations for discharges for union activity are filed before the petition, while 76% of these are filed before the election. The punchline is this. Contrary to previous witnesses who claim that employers have little or no ability to communicate effectively with employees, the voicing of employer opposition to union representation begins from the moment employees begin talking about the union and continues day after day, week after week, leading up to the election. Our study reveals the pervasiveness, consistency, and intensity of employer opposition to workers exercising their rights to union representation. And we'll submit the full study as part of our written testimony.
Thank you for your comments. Questions?
I've got a question about the data and how you categorize it. So you said, I think I heard, that 47% of, in this sample, particularly in the year 2003, that in the election cases that occurred within that year, that 47% of the charges that were filed relating to employer conduct, employers who were involved in those elections, occurred prior to petitions. How did you determine, or did you determine, the nature of the conduct? That is, how do we know that that was campaign-related conduct which led to the charge?
This is through reading one by one every bit of evidence in the file. So the testimonies, the affidavits, the decisions by the board itself, complaints, settlement agreements, withdrawals. So we went through every single file and determined, based on the evidence in those files, that these were campaign-related serious allegations.
And campaign-related in the sense that the charge resulted from active employer conduct. That is, for example, we see charges where organizing begins, and in the course of the organizing, union reviews employer's handbook and finds rule and files a charge based on the rule. So that seems to me different than a charge which results from active employer campaigning. Did you sort in that respect?
Yes, we have charts that are very explicit in terms of which charges we identify as serious campaign-related unfair labor practices versus non-serious allegations. So that's very clear in our report, in our tables.
Well, this is not so much a question of serious versus non-serious, but whether the conduct which formed the basis of the charge is properly categorized as campaign conduct. Do you feel like your sifting was sensitive to that question?
Yes, and we also, of course, in the peer review process, as well as invite others to follow our tracks in terms of also doing this kind of analysis. It's all public information. But we're very confident in our typology of the description of the charges as being campaign-related.
And you indicated that a preliminary version has been published, and what's the plan for the rest of the study?
So because it's so labor and time intensive, we were only able to do that 1 year in our sample. We're continuing to do the analysis for the other 4 years in our sample. At that point, we'll submit variations of this to peer-reviewed journals.
Thank you.
Questions? Questions? Thank you very
Great.
much.
Thank you.
Appreciate your being here with us today. We thank all the witnesses from this morning for your comments and for being with us. I hope you will join us for the afternoon session. We're going to break now. We will resume promptly at 1 p.m. I will remind you once again to take your badges and numbers with you, and we have escorts to take you down to the lobby, and we stand in recess. Thanks very much.